Hi. Today I'm going to talk about two very common motions that are filed before the immigration courts. And you get a lot of questions about these two motions. They're called motion to recalendar and motion to reopen. I'm going to talk about the difference between the two and provide some examples and answer some questions that you're getting from our clients and our listeners. With that being said, let's move on. Okay. So, a motion to recalendar, I actually made a separate video on this and talk about it in detail. But a motion to recalendar is filed when a client's case is administratively closed before an immigration judge. This means that the client's case is sleeping and you're filing a motion to recalendar the case before an immigration judge so they can have it here. Okay. And a motion to recalendar can be filed by the client himself, known as a respondent, or DHS government, or sometimes it can be filed by a judge, but it's either triggered by the applicant or respondent or DHS. And once this motion is filed, motion for recount is filed, the case is usually put back in front of immigration judge for a hearing. A motion to reopen is filed when there has been a final decision by an immigration judge. So there has been a final decision by an immigration judge, and you're asking the judge to reopen this matter. Okay. So if the client's case, so for example, if a client, so for one of our clients, his case was finished before an immigration judge, and the immigration judge denied his case, and he received the removal order. But then subsequently he got married to a U.S. citizen, and we were able to go back and to that court and file a motion to reopen. Okay. Now, there is a big difference between the timeline that is filed for a motion to recalendar and a motion to reopen. So there are usually three different type of timelines as filed for a motion to reopen. So ordinarily, so the first one is that a motion to reopen has to be filed within 90 days. So if, for example, a judge has issued a removal order or make his decision denying an application before an immigration judge, that client has 90 days to file the motion. If there is a new fact or new evidence that asking the court to reopen this case. So, for example, if, there has been a new relief that's discovered that wasn't available, so that could be a motion to reopen based, for example, someone getting married to a U.S. citizen, that could be a basis to reopen a case. If a client has received a removal order, and for example, they didn't have proper notice, or there were other circumstances that where they were unable to attend their court hearing, usually there is a 180 days timeline or deadline to file a motion before an immigration judge. And that's usually due to some sort of exceptional circumstances. So I'll give an example. So for one of our clients, actually there were two, they received a deportation order because their father had left the country, and obviously since the three of them were together, the father had left the country, and they received the children received the deportation order. So luckily, their mom came to us, and I was able to review the file. And even though the time of this case was extremely insane, so she came to me, and we only had like literally 2 weeks to reach the 180 days, and I literally filed a motion within the 179 days. So If I would have been late, like only like 1 or 2 more days, the judge or the court would not have accepted that motion. So we stated the exceptional circumstance in this case that the father had left and the children did not have notice of the court hearing. That's why they received the deportation order. So based on that exceptional circumstances, the judge reopened the case, and later on they did suggest another green card holders. So that's a very, very happy news. And they were actually in my office like a couple of weeks ago, and it was just crazy for me to see them how like grown up they were because they had been with me for so long. It's a very common story of us. Okay, so that's a motion to reopen based on exceptional circumstances that has to be filed within 180 days of the date of removal. Okay, so of the date that the immigration judge has issued a deportation order. I want to emphasize this that everything about immigration and immigration law is about dates and time. Okay, so whether you're applying for different type of reliefs and everything, when you enter the country, when you apply for your immigration relief, your marriage and all that, the dates are very, very important. A lot of clients actually miss this. But whether you're represented by an attorney or you're doing this case yourself, uh, just make sure you need to be wary of your dates. And another thing I would like to remind our listeners is that if you're in immigration court, make sure you are very fully aware of the date of your hearing. Okay, if you miss that day, and you receive a deportation order, it's very expensive to reopen this type of cases because the attorney has to file a brief, declaration, all that, and those documents and the time you have to spend these cases can be very time consuming. So please hear of that. All right. Another way to, or the third way to reopen a deportation order, that's if the client did not have the notice. So a motion to reopen based of lack of notice where the client completely did not have the a notice of the timing date of the hearing, that can be filed at any time throughout the after the hearing. So if you can show or prove to the court that you did not have notice, anytime the motion is filed, the judge or the court will entertain the motion and will review the document. So for one of our clients, they had, I believe this was sometime in 2017 or 18. So she had gone to a notario, and this case was like a notario fraud. She had paid this notario for a green card application, but it was like a notary fraud, and they filed an asylum application for her. She got the work permit, but then they closed down shop and took all of her money, and everything from that case was under the notarious name and address. So when she came to us, she had received the deportation order, and we looked at the documents. We did a FOIA, and then we were in the motion. We were able to show the court and the judge that this was the address of the notario, and at this time, my client was actually living at this address based on her taxes, lease, and other information. So luckily, you were able to reopen the case, and even though the motion was filed like 3, 4, 5 years after the removal order, the judge reopened the case, terminated, and she's also a green card holder right now and gonna apply for citizenship next year because she was able to apply for a green card through a U.S. citizen. Okay, U.S. citizen suck. So a motion to reopen for lack of notice is when the client or the respondent did not have a notice. Okay, now if you had if you, for example, went to your first court hearing and you did not follow up with the court, and then at your first hearing the judge told you, hey, if there's a change of address or something, you need to like make sure you change the address, but then you refuse to go to court on your second court hearing. It's gonna be very hard to argue that case. It's gonna be very hard to argue that motion because you were present in court, you had noticed, and the judge gave you oral and written notice to change your address. So I get a lot of these cases, and not all cases are good, but a lot of these cases where clients refuse to go to their second or third court hearing for whatever reason, and they come to me like 2 3 years after their deportation, and they say, "Oh, you what can we do?" And I tell them like there are like different ways, but it's not gonna be easy because you did have a notice of your court hearing. Um, if you have any other questions, please don't forget to contact our office, visit our website, and follow us on social media. Stay tuned.